This is the Justice Fighter Podcast. With attorney Gerald Griggs. Where we have conversations on social justice, civil rights, and political news that affects us all. Let attorney Griggs put you on game. Only on the Justice Fighter Podcast, y'all.
What's going on, y'all? It's attorney Gerald Griggs, a Justice Fighter, and we are back on the Justice Fighter Podcast. And there has been a lot of things that have happened since the last taping of the Justice Fighter Podcast. And so as we are taping on February the 20th, 2024, want to get you guys updated on some of the things that have been happening in Georgia, have been happening in Atlanta. And I mean, if you have been living under a rock, you don't know about what's happening down at Fulton County Courthouse. And that is the election interference case featuring Donald Trump and a host of others. And there was a 2-day hearing on the motion by the defendants to disqualify the district attorney as well as to dismiss the indictment. So I want to get into that in a few minutes. But before we get into that, let's talk about Atlanta, y'all. Atlanta has been doing a lot. I think I saw a post on social media a couple days ago that said Atlanta's been on TV 3 straight weeks. And so, again, as somebody who loves Atlanta, somebody that's from Atlanta, shout out to Atlanta because we have been on TV for 3 straight weeks, starting with the Grammy win by Killer Mike, the 3 Grammys that he won, and then, of course, was arrested. And then the Super Bowl, which turned out to be a football game at the halftime show of Usher Raymond. And so let's just jump off with the thing that everybody knows. Atlanta influences everything. And being a native Atlanta, it was a proud week to see a brother from the west side of Atlanta win 3 Grammys. And then, of course, the unfortunate incident that happened, and I'm sure that will be resolved. But shout out to Killer Mike for that huge win of those 3 Grammys. And we're not going to let what happened after that overshadow the win because he said he did it for Atlanta. Atlanta, we did it. Shout out to Mike. Shout out to the A. Shout out to all other artists that are his contemporaries and those that came after him because it's huge for Atlanta artists to win 3 Grammys. And so shout out to him. And let's give him a big round of applause. So shout out to Mike for that big win. Salute, brother. And so, you know, people kept saying we've been on television for 3 straight weeks. So we transitioned from the Grammy Award to Usher Raymond's halftime show at the Super Bowl. And I have to be honest, I watched the entire Super Bowl. It went to overtime. It was a great game between Kansas City and the other team that played. But just joking, y'all. Shout out to San Francisco for a wonderful season, the 49ers and the Chiefs. And it was a great game. And we all thought it was going to be the Travis Kelce, Taylor Swift show. But Usher Raymond, Ludacris, JD, Alicia Keys, the bands, of course, all of the artists that were there assisting Usher, and then the show. It was an awesome show. I mean, it was sort of like an Atlanta R&B homecoming with hip hop mixed in, and roller skating, and there was stripper poles. It was definitely a sight to see if you're from Atlanta. It summed up what the last 30 years in Atlanta have been with regard to R&B. So shout out to Usher. That was huge. Usher came home and was greeted at the airport, and then, of course, down at the Mercedes-Benz Stadium. He was honored there. But shout out to Usher as the Super Bowl turned out to be the Atlanta features, the Super Bowl. And so the winner of the Super Bowl was the Kansas City Chiefs and the entire city of Atlanta, of course, because of Usher Raymond. So shout out to Usher. That was huge, brother. Thank you for always showing up for the culture here in Atlanta and bringing Atlanta culture to the entire world. So shout out to Usher Raymond. And then, of course, there is what's happening at Fulton County Courthouse. And so, like I said, if you've been living under a rock, you don't know about the indictment of Donald Trump and several others for RICO conspiracy to intervene in the 2020 election in Georgia. And, taking politics out of it, just looking at it through a, strictly legal lens and a lens towards the evidence, I got to watch not only the first day of testimony, but was present for the Friday day of testimony. And so I wanted to get on here and recap, because there's a lot of conversation that's going on all throughout the internet about this case and about the allegations that were made in Miss Ashley Merchant's motion filed on behalf of her client, Mr. Roman. And, the thing that I think is getting lost here is that it's a motion. There's currently no real investigation going on. The GBI has said they're not investigating it. And so it's a motion where the defense is going to have to prove, and submitted evidence to attempt to prove, that there was a conflict of interest that will disqualify the district attorney from prosecuting this case. Now, again, I want it to be objective. I want to look at this through a clear lens and to listen to the evidence to see if there's any there. And currently, after listening to 2 days of evidence, I watched the live stream when I was out of court on Thursday, and then I was present for all of the testimony on Friday. And I have to be frank, as a 20-year veteran defense attorney, I don't see any evidence of a conflict of interest that will adversely affect the parties in the case, namely the defendants. Now, there's been a lot of evidence, a lot of testimony, and now an admission that there was a romantic relationship between the district attorney and her special counsel, Mr. Wade. But I don't really see how the evidence has tied that to a conflict that would disqualify the district attorney or the special counsel. Now, we're going to go over some of the evidence that came out. The evidence that came out was, of course, Ms. Willis testified that there wasn't a relationship and that she never profited from any financial dealings with the special prosecutor and never received monies from Fulton County as a result of that. Mr. Wade, he testified, and he, of course, testified that there was a relationship, that the relationship started after he was appointed special prosecutor, and subsequently the relationship ended. Now, they are differing in their beliefs on when the relationship ended, but they were clear the relationship has ended, and at no point did it have anything to do with the indictment, the investigation, the indictment, and subsequently now the trial that is coming in this case. And so what Ms. Merchant was trying to prove in the motions and the testimony was that, one, the relationship started before he was appointed special prosecutor, and that he benefited as well as Ms. Willis benefited from the appointment. And again, the evidence that came out, there was a former employee of the district attorney's office who testified that the relationship started somewhere around 2019. Now, Ms. Willis, then the district attorney's office refute that and say it happened in 2021, I believe November of 2021, which would have been after the investigation into election interference, and then ultimately led to the indictment on election interference. And so here's what people need to realize in a motion hearing. In a motion hearing, the defense has the burden to prove by a preponderance of the evidence the allegations that they're making. So now when you have two witnesses that are testifying to two different things, the fact finder, which would be the judge, has to make a decision on the credibility. And so in that situation, when you have two witnesses that are testifying to two different factual scenarios, then you go a little bit deeper. But that was not the only evidence that came out at the hearing. During the course of the hearing, in the second day of trial, Governor Roy Barnes testified. John Floyd, who is the father of Fani Willis, testified, and there were several others that testified, which some of that didn't get in, to discredit some of the testimony of the witnesses for the defense. So, of course, Terrence Bradley, who's the former law partner of Mr. Wade, testified. He invoked attorney-client privilege, so much of what he testified to had no bearing as to what the defense was trying to prove, because they could not pierce, at least until this point, to this recording, they could not pierce the attorney-client relationship. And for those that don't understand what that is there's a privilege under the rules of professional conduct, as well as now in case law, that anything that someone tells their lawyer is privileged conversation. So if it relates to the scope of the representation, it cannot be used against the person. So the person asserting the privilege would be Special Prosecutor Nathan Wade, who was the law partner of Mr. Bradley, but also was his client during the pendency of the divorce. And of course, during the course of this trial, it came out that the divorce proceedings started somewhere between 2018 and 2019. The witnesses weren't as precise as people would like because, again, people's memories are foggy, and they don't have the engagement document, which is the contract that somebody enters into when they become someone's lawyer. So it started in about 2018, 2019. So anything that Mr. Wade would have told Mr. Bradley during the course of his representation would be subject to attorney-client privilege, and they couldn't get into that. So ultimately, the judge ruled that he would have an in-camera inspection of the witness, of the facts upon which the defense wanted to go into, one of which would have been when was the relationship with Ms. Willis started. And so Judge McAfee took that up in chambers. So we still don't know whether or not that information will come in. But right now, as we sit here in recess, the evidence is not coming in. So there's no full definitive corroboration of the former employee who came in and testified that the relationship started in 2019. But what we do have is Miss Willis's father, who was living with Miss Willis from, I think he testified, to 2019 until the present. He said he was living in South Africa. He came and moved in right during the pandemic. And of course, being in South Africa, he knew about the pandemic before March of 2020, so it would have been 2019. He lived with her and her daughters in the house in South Fulton from 2019 to the present. And so he testified that Ms. Willis did not have a relationship that he knew about with Mr. Wade in 2019 or 2020. And he found out about 7 weeks ago, when all of this happened, that there was some sort of relationship. So there are some discrepancies and conflicts in the testimony, and only the finder of fact will have to resolve those. But again, as I told you in the beginning of this, in order for the defense to be successful on their motion, they have to prove by preponderance that the relationship, one, started in 2019, and thus there was an incentive to hire Mr. Wade as a special prosecutor, but two, that Ms. Willis profited off of that relationship and thus some way tainted the ability of the defendants to get a fair trial. Again, as you can hear in my voice, even under that theory, that's a stretch. But from the evidence that's been adduced so far, I don't see a connection, let alone a connection that proves by preponderance of the evidence. And so Ms. Willis testified in her hearing that, one, there was no conflict. Two, and she was very adamant in this, that she's not the one on trial. She didn't break any laws or commit any offenses that would be subjective to a disqualification. And three, this entire thing was a fishing expedition. Now, after sitting through 2 days of testimony, it's still not clear to me where the actual conflict is, because the conflict would be maybe the district attorney having a relationship with a defense attorney and thus prejudicating the defense attorney. But a prosecutor and a prosecutor having a relationship, they both have the same interest, which would be to prosecute the defendant. So I don't know how this theory of a conflict, but what I'm seeing on social media is people conflating a potential ethics violation with a criminal offense and or a conflict which would disqualify the district attorney. Now, the standard for disqualifying a defense attorney, the standard for disqualifying a prosecutor has been set out in Georgia law under Williams versus the state, which says that you have to have, one, an actual conflict, and then two, it must prevent the defendant from receiving a fair trial. And then it lays out the standard. And of course, they went into all of that, and I'm not going to bore you with the minutia of what the law says under the Supreme Court of this state. But the key in this hearing so far is there, one, has not been a connection that there is a conflict of interest that is detrimental to any defendant. Now, in the wild world of social media, there's a lot of innuendo and supposition, but there's really no evidence of it. And then in a courtroom, there was absolutely no evidence of it so far. And so I think what we're learning in this whole trial is that there's the court of public opinion, which is still out, and then there's the court of law, which there has been no evidence. Now, strictly for the court of public opinion, the salacious details that have been gone into this hearing, I've never seen before in a courtroom. And I honestly believe there's no place for it in a courtroom. People's personal lives should have no bearing. I mean, even for a criminal defendant, there are rules of what character evidence can and cannot come in because of the prejudicial nature being solely solely outweighing a probative value. But in this case, the probative value of any of this is just a salacious information. There absolutely no probative value in many of the things that were testified to. I mean, they were going into all sorts of things of, where Miss Willis lived, how many vacations she went on, who was in the vacations, what she liked to drink. I mean, all of these things that had nothing to do with the underlying issue of whether or not there was, one, a conflict of interest, and two, the defendant was adversely affected, which is what is necessary to disqualify the district attorney. And here's the other thing. Even if the defendant is able to prove to a preponderant standard that their rights are being adversely affected and cannot receive a fair trial, the remedy would be the removal of the district attorney and the appointment of another district attorney, and the case continues. So what I'm struggling with, and what I think people should be struggling with, is why was there a hearing for 2 days on this? There are so many other things that in this case and other cases we could be doing with our judicial resources than intruding into the bedroom and the relationship of a sitting district attorney. Now, as you know, many of y'all who listen to me or know me know that I'm very good friends with Ms. Willis. I've been so since I was 19. So in a perfect world, we would not have to have this conversation. But I still don't think that anybody, sitting district attorney, any attorney who's handling a high-profile case, should have to have their relationship status be the subject of a 2-day trial. Because that's what it was. It wasn't a motion hearing. It was a 2-day trial of Ms. Willis. Now, she acquitted herself very well. She came out. She answered the questions. She showed fire that anybody would when they are being attacked like this. But she also said one thing that struck me. And what struck me was, regardless of how much you try, I'm not the one on trial. And what I think the defense needs to be careful on is that at some point this motion is going to be ruled on. And it may be some appeals. It's going to make some interesting law. But I don't think it's going to disqualify this district attorney. And, we are all zealous advocates within the bounds of the law. And I think she's going to become even more of a zealous advocate within the bounds of the law because she's been attacked. And her father put it so succinctly. she's had to move out of her house because of the threats of bodily harm that have come to her because of taking this case and the other case to bring it to court. And that should never happen. I mean, cooler heads should prevail. Yes, everybody is entitled to their opinion. They're entitled to be advocates for their side. But no one in this career should have to worry about their safety or their family's safety simply because of a case. And so that's where I want to leave this conversation. Regardless of your beliefs of what should or should not happen in any case, in this case, the focus is whether or not the 6 million Georgians who voted in the presidential election in 2022, whether or not someone attempted to mess with their rights at the polling precinct. Not who's sleeping with whom, who's going on vacations to Belize or Napa Valley or what type of alcohol individuals like to drink. That's not what we should be talking about. And so as we wait for the judge to rule, and again, I'm going on record, think the judge is going to deny this, we need to be careful both as citizens, as lawyers, as people that are interested in politics. This stuff's got to stop. It's got to stop because nobody is putting the defendant's character for whether or not they commit adultery, whether or not they engage in activity that may not be ethical on trial in this case. But there are rules, and what's good for the goose can be good for the gander. And so that's just something to think about as we continue to go through this case. I'm very interested in this case because it appears, that this is probably going to be the Georgia's longest RICO case. And that's saying a lot considering APS was Georgia's longest RICO case. And now YSL is Georgia's longest RICO case. And if we continue with these type of motions in the Trump alleged election interference case, it will be. And we still have not gotten to the crux of the issue. The crux of the issue is whether or not somebody on a phone call asked the Secretary of State to find 11,000 votes, which is one more than my opponent. That's what this whole case is about. It's not about smoke and mirrors and who's sleeping with whom and, what may or may not have been the incentive for any of that. It's not about whether somebody had credit card receipts or paid in cash, which, as Mr. Floyd said, and that was some of the testimony, black people are known to pay for things in cash. Black people are known for keeping large amounts of cash. I never thought I'd hear things like that in a courtroom, but we have. And we have to ask ourselves, is this the path that we want to go down in our criminal justice system? Because there appear to be two tiers of justice. I must admit, if any of my clients would make these type of allegations against a prosecutor, there would have never been a hearing. It would have been dismissed on the pleadings. And there'll probably be sanctions. So I just think that we have to get back to what the rules of professional conduct say, the canons of ethics. If there are ethical violations, there are other venues to address those things. That would be a bar issue. That may be a Fulton County Ethics Commission issue, but it's not a place in a courtroom. Unless it's a rape trial. There's no reason to get into people's carnal behavior unless it's a rape trial or sexual assault, and that's not any of these. So it's been interesting. I knew we needed to talk about this on the Justice Fighter podcast. I was in the courtroom. I was sitting next to former Mayor Shirley Franklin and Mayor Andre Dickens, and then there was Bishop Jackson was there. It was so many people in that courtroom, and it was interesting to hear. But I think at the end of the day, the motion gets dismissed. We'll move on to more evidentiary motions, and then ultimately it'll get to a trial, and 12 citizens from Fulton County will make a decision. But I'm going to continue to cover it. I'm going to continue to make sure the will of the millions that voted are focused on, but we got to get back to the practice of law, y'all. And so as a social justice matter, it must really matter that we focus on what the law actually says in a courtroom and not the court of public opinion. So I'm Attorney Gerald Griggs, the Justice Fighter. This has been the latest episode of Justice Fighter Podcast. You can get the podcast on all streaming platforms. Make sure you share. Make sure you comment. I'm going to have some of y'all come on. We'll talk about these issues, whichever side you're on. And let's focus on social justice because it's a whole lot going on. But until the next episode of the Justice Fighter Podcast, y'all be safe.
This is the Justice Fighter Podcast. Justice Fighter Podcast. With Attorney Gerald Griggs. Attorney G. Where we have conversations on social justice, civil rights, and political news that affects us all. Let Attorney Griggs put you on game. Only on the Justice Fighter Podcast, y'all.